the UK case, it's a decision that has been delivered in the dispute between Optis and Apple. In this specific decision here, we had also other parties involved, and particularly parties with whom Optis and Apple have concluded licensing agreements. So I'm going to explain that in a moment. This is a decision of the Court of Appeal that has been delivered in the 7th of October last year. Now, this dispute between Optis and Apple is a dispute that has been going on for a while. We have seen several decisions coming both from the UK but also from the US in this dispute. It has been active in both jurisdictions. We have covered different topics so far. For example, from the UK proceedings, we have covered issues like the availability of injunctive relief when it comes to SEP infringement. We have covered also the decision of the court regarding the rate determination, so that also the front rate determination. The courts here in the specific case have taken the step to determine the terms of a license agreement between the parties. Today, we're going to focus on the confidentiality issue, and that's why our facts and the background that we're going to discuss now is really tailored to this aspect of the proceedings to help us better understand where this decision comes from and what issues, what problems it addresses. Generally, as I said already, this is a case that has started back in February 2019. It was then when Optis sued Apple in the UK. So it's a decision which it's our proceedings that are already running for almost 6 years now. We had all of these issues that I mentioned before that the courts clarified, starting with infringement issues, the technical trials, which were decided in the first instance by the High Court. Some of them were also went to the appeal. We had the rulings about the availability of injunctions, which were also appealed. For us, very interesting was the ruling that the High Court delivered in first instance in May 2023, which was a ruling by which the High Court determined the license terms for a license that Optis should grant to Apple, respectively that Apple should obtain from Optis. So this was the ruling delivered in the May 2023. There was an appeal filed against this ruling, and we're going to see in a moment that this has been decided also in the meantime. But let's focus here on the ruling itself. So the ruling was delivered in May and was published then in June, some weeks later, by the High Court. In this ruling that was published, the court had many reductions. And there were particularly issues reducted that were considered to be sensitive. We are talking here about primarily commercial information coming from third-party license agreements, which played a role in these proceedings as far as the determination of front terms and conditions is concerned. So both parties, Optis had disclosed license agreements that it had signed with other licensees. I think it was 9 agreements in total. Most of them were agreements on a percentage rate basis, but there were also a couple of agreements, and especially one which the court really considered in its decision, an agreement with Google that was on a lump sum basis. And on the other hand, Apple had also used agreements with other parties in the proceedings, 19 licenses in total, and these agreements were all on a lump sum basis. So what had happened in these agreements, the experts of the parties dealt with this agreement, tried to unpack them to make them comparable. And in the decision of the court, all of this data should have been included because the court looked at the evidence and presented its views on the evidence that the parties had submitted, the expert had submitted, and it included this information in its ruling. Because exactly there was, however, concern about whether, especially the data that came from third-party agreements, whether this could be disclosed and published without any confidentiality protection. This first judgment, published in June 2023 included full redactions of this information. So this information was not visible in the judgment. The court, however, made clear in the judgment that this extent of reductions should be looked at a second time, and there should be an assessment of what is necessary and what not. So the court made initially full reductions, but had already anticipated that there might be a need to change things to make basically less reductions, and opened a stream in the proceedings regarding this specific question. There was a hearing in July 2023 regarding this confidentiality aspects, in which third parties participated as well. And when I say third parties, I mean parties with which Optis and Apple had concluded agreements, which included Google, it was Qualcomm, Nokia, LG, InterDigital, Huawei. And the court heard about their evidence and the views about what should be published of the information concerning the licenses and not, and delivered a decision in February 2024 on these aspects. So this was a ruling which the court used in order to set some other terms of the license agreements apart from the royalty rates, which had been fixed back in May 2023. And the court also settled a less redacted version here, meaning that it found basically that some of the reductions that had been made in the first judgment published should be removed. So the respective data should be published, should be made accessible. This less redacted version was, however, not published. The publication was stayed pending appeal because this decision was appealed again. And with the ruling we are looking at today, the Court of Appeal has delivered its view on the reductions and what needs to be protected and what should not be protected. And maybe a spoiler here, to a certain extent, the Court of Appeal found that more comprehensive reductions than what the High Court suggested should be made. So we're going to look at that all in detail in a moment. What was interesting is that in the meantime, or before that, the Court of Appeal had also looked at the rate fixing ruling as such, and has also criticized that ruling and made significant changes, or asked the court to make significant changes. So at the moment, this rate determination is also not final. There are things that need to be clarified here as well. We are also going to look at that, of course, in the future if we have further developments in both aspects here, and we will report respectively if there is a need to do that. Now, looking at the decision itself, there are basically two types of information that the court looked at, whether they should be redacted or they should be published. The main part of the decision refers to financial information. And when we say financial information, we mean information about licensing rates, here particularly about lump sum payments or rates that have been calculated on a per unit basis. So this is the financial information. This was the main part of the decision of the court. We had, and we're going to look at that at the end, also some discussion around other type of information, not purely financial. For example, the information whether cross-licensing is involved in a specific agreement, on which the court also has taken some positions. But let's focus again on the financial information, because this was the main part of the decision. Now, the court started here by looking at the principles. So what is the principle that should guide its decision? And we have, of course, a fundamental principle that the decisions of the court should be visible and should be published in a way that allows everyone to understand the court's reasoning, the court's decision at the end of the day. What were the factors that the court considered? So this transparency and the principle of open justice are crucial the Court of Appeal confirmed that, but it also said that there can be exceptions for the yet more fundamental principle that courts work in the interests of justice. So the court said, of course, the fundamental principle is that everything should be disclosed and everything should be published. However, there are some exceptions, and there is a weighting that needs to be done between exactly this interest of justice and the interest that is incorporated in the principle of open justice, of publication, of transparency. This balance, according to the Court of Appeal, is fact sensitive. So this is something that you need to address on a case-by-case basis. You need to ask yourself whether in the particular circumstances the interests of justice outweighed the principle of open justice. And this, in the eyes of the court, is a general principle that applies to any type of information that might be worth to protect. There was some discussion both in the first instance decision and also in this decision here about trade secrets. So the High Court had found that trade secrets should be more or less automatically protected. So if you can establish that an information is a trade secret, then there should be really no weighting of interest there. There should always be an assumption that the interest to protect this information outweighs the interests for publication. The Court of Appeal questioned that and rather said that if you have trade secrets, then you would warrant protection almost always. However, not automatically. So some degree of weighting should be done also when you have trade secrets. So the question is, what happens if you don't have trade secrets? Is this something that still requires to do this exercise, to do this weighting, or is it only this discussion around when we have trade secrets? Because maybe for our better understanding, trade secrets is a type of sensitive information that needs some qualification. So to have a trade secret, you must have something that is worth protecting, that has a commercial value, but it's also something that is subject to specific measures that has been taken by the owner of the trade secret. So not every information that might be sensitive, also from a commercial perspective, is a trade secret. You cannot qualify everything as a trade secret. So the question here was more or less, should there be protection of other type of information that might be sensitive, which does not qualify as a trade secret? And the Court of Appeal said that this is the case, that even lower grade financial information, meaning something that might not be a trade secret, is under circumstances entitled to protection. And this, in the eyes of the Court of Appeal, applies for the financial information in the present case, especially the third party's financial information. The court did this weighting exercise here and found that if the third party's financial information, meaning the rates and the conditions that third parties have agreed with the parties, with Optis and with Apple, if this would be published, then this would cause to the third parties real commercial harm. So that's why there was a need to make reductions regarding this information. The court acknowledged, of course, that in this case, when you would make these reductions, there would be not a full publication of every detail of the reasoning of the court, but nevertheless, the court found here that with the information that is going to be published, the public will still be in a position to understand how the court made its conclusions. So the court basically confirmed here that this information is worth of protecting, especially the third party's financial information. And this means that you should basically tolerate the fact that you might not be seeing every figure which the court used in its decision being public, but nevertheless, this is something that you should accept here, because if you wouldn't, then you would really cause commercial harm to the third parties. So this was the principle. And now, of course, the question that arose was, to what extent should the reductions be made? Because the financial information here was basically in two different categories. We had lump sum amounts that have been either extracted directly from agreements or had been derived from agreements in an unpacking exercise by the experts. And we had a second, let's say, group of financial information that was relevant as well. These were per unit figures that had been unpacked by the experts of both parties, again, in an attempt to make the license agreements comparable with the present case here. And we had unpacked per unit figures, both expressed as a percentage of the sale price and also as a dollar per unit price. So these were the financial information, the two major categories of information that was to be decided whether it should be protected or not. The High Court, in its decision, had a tendency to distinguish between this information and to fully protect lump sum rates, so not disclose them, not publish them in the judgment, so keep them redacted, but to publish the unpacked per unit figures. So all this information that basically came from the analysis of the experts in these proceedings. The Court of Appeal disagreed with this distinction. So it found that there is no sound basis for distinguishing between lump sum figures and the unpacked per unit figures, which means consequently that both are to be protected the same way. So the court saw no difference here for distinguishing between the lump sums and the per unit figures. Why? Because in contrast to the High Court, the Court of Appeals saw that there is a risk of repacking the lump sum data from the per unit figures. In a sense, basically saying that there is this, if you publish the per unit figures, there is a strong possibility that you will also get to the lump sum rates at some point. You can reverse engineer it in a sense. Now, the High Court did not see a great risk in that, because it said if you would do this exercise, you would never get the right number, because for redoing things or making this repacking, you would need also access to information which is not included in the judgment. For example, on sales figures, etc. But the Court of Appeal did not agree with that. So the court said basically there is potential information available. Maybe you need to have to pay to get access to that, but there is information available that would allow this repacking. So it's not excluded. But irrespective of that, the court did not see a problem only if this repacking would allow the lump sums to be calculated with pinpoint accuracy and certainty, as the court put it here. Because even if you would have, based on this per unit figures, a rough estimate of the lump sums, in the eyes of the Court of Appeal, this would do as much harm to the negotiating position of the third party as if you would publish the lump rates themselves. Why? Because the court said even if you would publish this rough data, and even if the data that would be extracted from the per unit figures or reverse engineered by the per unit figures would be inaccurate, this would create difficulties for the parties of the agreements with Apple and Optis, because if they would negotiate with other parties, they would be confronted with these numbers, and then to rebut these numbers that come from reverse engineering of the royalty, of the lump sum royalties based on the per unit figures, you would need to disclose confidential information, which you would be likely not be in a position to do. So the court did not see this risk of repacking the lump sum data from the per unit figures to be very low, as the High Court did, and so that this risk is significant and therefore justifies treating both the lump sum figures and the per unit figures the same way. The court even added that even without a repacking, the rates, the per unit rates themselves, will be relied by other potential licensees of the third parties. And they would have a value, even if this is just data that has been, let's say, extracted and unpacked from real agreements. So it's not really the actual data from the licenses itself, but it has a value because it is data that has been derived from actual license agreements. So it has a real basis on which it has been extracted, it's been derived. And of course, the data represents the view of experts in accounting and experts in this type of exercise. So there is a value even in using the per unit rates as they have been unpacked by the experts. So this was another reason why the court found that here a distinction protecting only the lump sum figures and not the per unit figures was not the right way to go, and there was no real reason, no real basis for making this distinction. So the court said everything should be protected in this sense. Having said that, the court then looked at some of the arguments that had been raised for supporting a broad publication of this sensitive financial information, and it disagreed with some of the positions again that the High Court had taken in the first instance ruling. There were some 3 points maybe that we should look at here, particularly the High Court had said that maybe this information is not worth of protection because it is dated and therefore not especially commercially significant. So the idea was to say that this is not, at least part of this information is not coming out of agreements that are, or that are more or less that are old agreements. So their value for the actual rates and the actual terms and conditions that are being offered today is low, is not very significant. The Court of Appeal said, however, you should consider in this context that even licenses that have expired by the time that the High Court ruling was delivered on the friend determination, they still have value. And the Court of Appeal said this is indicated, of course, by the fact itself that the licenses, this type of licenses, even dated or even expired licenses, have been relevant for setting the rates in trial. So if they had been relevant for setting rates in trial, they will be also relevant for negotiations. So saying that these are old agreements is not really a factor that can justify publishing this information in the judgment. Then the High Court had also taken the view that the commercial disadvantage for third parties by a publication of these rates would be minor. The Court of Appeal was not convinced by that argument either. It found that the publication of the rates would allow licensees to push for lower rates, and there could be harm out of that, which had also been presented by the High Court, but in the eyes of the Court of Appeal not considered sufficiently. The Court of Appeal also stressed here that this evidence of harm, the fact that not all third parties had presented the court with this evidence, but evidence came from Apple, was not a factor that changed things here. It was an irrelevant factor, so the court should have taken that into account. Finally, there was another view expressed, or another thought in the first instance ruling, saying that given the front regime, there is an interest in publishing the rates. Here, the Court of Appeal had a different view again. It said you have to look at the IPR policy that is relevant here, which was the ETSI IPR policy. And you should consider that the ETSI IPR policy, although there was some discussion, was not amended to require transparency regarding grades. So the Court of Appeal said it's therefore for the courts to respect that, and the court should not unilaterally take a different line than the ETSI IPR policy. So also this argument for refusing protection of financial details in the present case was not accepted by the Court of Appeal. Finally, the court, as I mentioned in the beginning, turned to other information that should potentially be protected as well. And here we had two different questions to answer. The first one was whether information about whether a license agreement allows for sub-licenses should be protected, should be redacted. This was the case with some of the licenses that were involved here. And the second question is whether information about whether a license agreement involves a cross-license should be published or not. The court said regarding the first question that it was not convinced that a reduction was needed of the information of whether a license agreement allows for sub-licensing or not. Because the court said there is, of course, very high possibility that a license that permits sub-licenses might be more valuable than one license that does not permit sub-licensing. However, in the present case here, the court was not presented with specific evidence for justifying a reduction in the present case. So the balance of interest regarding this type of information was not sufficiently substantiated in these proceedings. So the court did not consider that there is a necessity to redact information of whether a license allows for sub-licensing or not. The result was the same also regarding the second question, whether the license involves a cross-license or not. Here, at the end of the day, the court allowed this information to be published. In principle, however, the court did not decide this question because the licensor that was affected did not seek to keep this information secret in appeal anymore. So the court did not really need to decide that. What the court decided, however, is that the first instance ruling of the High Court should be corrected to include the correct information about whether a specific license involves a cross-license or not. Because regarding a specific license agreement, the High Court had included wrong information about whether there is a cross-license element or not in its ruling, and had then refused to correct this information in later on. So the court said here basically you can publish that because also it was not contested in the appeal proceedings. But if you publish, you should make sure that this is the right information, the correct information. So that's the answer of the court to the second question. So generally, the court was very cautious here regarding the financial information and accepted that there is a broader need to protect this information and accepted reductions that went beyond what the High Court would do. Regarding the other information about sub-licensing and cross-licensing, the court did not see a need to redact or protect this information for publication.